Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 21-5179, United States of America versus Honeywell International, Inc. Mr. Primus for the appellant, Mr. Janda for the appellate.
Good morning.
Good morning. May it please the court. When Congress enacted the False Claims Act in 1863, the prevailing common law at the time recognized joint and several liability for joint tortfeasors with no right of contribution. And that has been the unbroken rule courts have applied ever since. As a result, when multiple parties are jointly liable for the same false claim, any one of them can be held responsible for 100% of the damages, while others may be responsible for nothing at all. And that is the very nature of a joint and several regime with no right of contribution. It is focused on full compensation for the plaintiff and not on an equitable apportionment of fault among the defendants. The question in this case is, what is the appropriate measure of the offset for damages already recovered by the government from other defendants for the same false claims? The answer under the common law and common sense is a pro tanto set-off for all money received by the government. In response,
you keep talking about the common law and the background rule when the act was passed, but what about the statute itself? It says that any person who defrauds the government is liable for 3 times the amount the government sustains because of the act of that person. And under your theory, quote, any person who defrauds the United States government, namely Honeywell, will not have to pay a cent, right?
well, not exactly on the last point, Your Honor, because it would still be liable for civil
I'm talking
penalties.
about treble damages.
Sure, on the treble damages part.
But doesn't the statute require any person who defrauds the United States to pay treble damages?
No, Your Honor, not in the multiple tortfeasor context.
Wait, just stick with the statute. Suppose we weren't talking about multiple tortfeasors or common law or anything. Just look at the statute. You're suggesting a rule, the pro tanto rule, that would result in a person who defrauds the government, namely Honeywell, in not being liable for treble damages. That seems inconsistent with the statute.
Well, no, Your Honor, if there were only one defendant, only one tortfeasor, that party would pay treble damages.
I'm talking about this case.
Correct. And in this case, the way Your Honor is positing the statute be read would indicate...
No, I'm not positing it be read anywhere. I was reading you the statute.
I understand.
Yeah.
And my response is that if it is read that way, and every person who is a party to a jointly committed tort is liable for 3 times the damages, then in theory, you could have 15, 21, 30 times damages, and no court has ever applied it that way.
Well,
and in fact,
what's the matter with that? I mean, even I think it was McDermott that said, it wasn't a statutory case, but McDermott says, quote, making tortfeasors pay for the damages they cause can be more important than preventing overcompensation. So the point is that as far as Congress is concerned and the taxpayers are concerned, it's definitely more consistent with the purpose of the statute than to have overpayment than to have, quote, any person who defrauds the government to go off to not pay treble damage. No?
Your Honor, if I may respond to that.
Of course.
McDermott, in our view, is completely inapposite. And McDermott itself says...
I wasn't suggesting that McDermott was binding. I was just suggesting that here's the Supreme Court telling us that overpayment is less important than requiring that tortfeasors pay. Well, in fact, we've said that too. We've said, Judge Leventhal said the same thing years ago in that, what is it, Rose? He said exactly the same thing. It wasn't a False Claims Act case. But...
Your Honor, the difference with McDermott is that McDermott was a case, first, where the Supreme Court recognized it was admiralty in an area of judge-made law.
Yeah.
And second, there was a proportionate fault. There is no regime of which we are aware, and the government has cited none, where there is joint and several liability and no right of contribution, yet a proportionate share approach to an offset. There's just
out of curiosity, where does the joint and several liability come from? What have courts said that there's joint and several liability under the False Claims Act?
Yes, the courts have consistently said that, and the Department of Justice has.
It's a question. I'm not challenging you. What's your best case for that?
Your Honor, I don't have it at hand. We've cited numerous cases in our brief where the courts have consistently held it's joint and several.
And how about no right of contribution? Where's that come from?
Yeah, where's that come from?
The no right of contribution has again been consistently held by the courts, and in US
Was it actually contested or just stated?
No, in most cases it's been stated and applied, but not reached as a holding. But we do believe that it is strong evidence of what the common law was at the time the statute was enacted, and we know that from, for example, the Lovejoy versus Murray case in 1865, which was just 2 years after the False Claims Act was enacted. And it recognized multiple common law decisions that said where there's full satisfaction of a judgment that the other defendants to a joint tort are not liable for it. And it recognized cases that were from multiple states that were decided before the False Claims Act was enacted. And as the Supreme Court has said multiple times, when Congress passes a statute like the False Claims Act, it does so against a backdrop of common law.
Well, but that's unless the statute itself provides otherwise, correct?
Well, if the statute itself is clear, then you
would look at the
language of the statute, certainly. But where the statute does not directly address the issue at hand here, the method for calculating offsets, the Supreme Court has said you look to the common law at the time.
And is your primary argument about the theory I suggested that it results in overcompensation for the government? Is that your main argument as to why literal reading of the statute doesn't work?
Our main argument is that a literal reading of the statute does not answer the question at hand and does direct the court to incorporate the background common law.
Where does it say that?
Well, we believe the focus is on damages and the treble damages and how to interpret that term. And the statute does not address a joint tortfeasor situation. If it says any person, that's not addressed to the joint tortfeasor situation. But we know that the joint tortfeasors are commonly accused of committing the same false claim. And as I said, the Justice Department, in such cases when it goes to trial, asks for an instruction of the jury indicating that only one judgment and one amount of damages can be obtained. And it does not ask for 3 times the damages against each defendant. The government's not even seeking that relief. And we're not aware of any court that has ever acknowledged that. And certainly in U.S. versus Bornstein, the United States Supreme Court, while it wasn't presented, certainly had no issue with and directed the lower courts to deduct amounts already paid from a False Claims Act judgment.
How do we know that the apportionment rule in reliance transfer should not apply to False Claims Act?
Well, for 2 reasons. First, in the admiralty context, the Supreme Court has been careful to say that it is involved in judicial policy and judicial lawmaking. And then in the Edmunds case, the Supreme Court specifically distinguished the common law approach when you're dealing with a statute. And the court said specifically in Edmunds that once Congress has spoken, we are not as free as we are in the normal admiralty judicial lawmaking context to create common law, federal common law. And the Supreme Court more recently has been very clear that courts should use all the tools, all the interpretive tools in the toolbox before resorting to federal common law. And that has been consistent across many cases, including most recently the Comcast decision.
You know, I'm glad you mentioned Bornstein because Bornstein's a False Claims Act case, right?
Yes.
Yeah. Because your response to my reading McDermott is that that wasn't a False Claims Act case. But Bornstein, the case you rely on, as you point out, the question of whether the pro tanto approach was required or not wasn't before the court. But it picked the approach that the government suggested because, and I'm quoting here, the government's approach, because it said, because it, quote, fixes the liability of the defrauder without reference to the adventitious actions of other person. and it actually said it twice. It said the prime contractors fortuitous acts did not determine the liability of subcontractors. So it's saying the same thing McDermott said in the context of the False Claims Act, namely that the liability of the person who defrauded the government shouldn't be, for treble damages, or in that case, double damages, shouldn't be affected by the actions of another party. That's what it said.
Yes, and the context in which it said that was in addressing whether damages should be doubled prior to or after the offset. And then it went ahead and directed the lower court to deduct 100% of the other defendant's payment in that case, which is consistent with what the Department of Justice usually seeks in these cases and what we're asking for here.
Are you familiar?
I see I'm out of time.
Are you familiar with any other case in which application of the pro tanto rule would mean zero liability for party?
Well, in the 1865 case of Lovejoy versus Murray, that's what the Supreme Court said the rule was of the common law.
And that's it. That's the last one.
No, but I don't know that this situation arises that frequently where the Justice Department is able to get all of its damages back from the other co-defendants before a case settles. And I would just indicate in terms of likelihood of settlement, the threat to each defendant of having 100% exposure on liability here apparently caused the other defendants to settle early.
And indeed, their settlements amount were very modest, except for one. Right?
There were two in the tens of millions.
One was 11 million, I think.
There's 130 approximately, and one approximately 70 million. They were substantial for Armor Holdings and for Toyobo. And I would just note, if the government had decided not to settle with those parties and the three companies that made these vests together went to trial, the government would seek one amount of damages. And then they would be trebled, and it would decide which of the three defendants would pay that. They would never get more than 3 times. And that's what the government seeks when it goes to court and offers jury instructions to the judges. That's all we're asking for in this case.
Mr. Prentice, so assume I agree with you that the FCA is silent on this question, but also that I'm not convinced that the common law in 1863 was settled. So if we were to set a common law rule now, I mean, the government suggests we should proceed on a case-by-case basis rather than set a particular liability rule. And I'm wondering, if the FCA doesn't set the rule and the common law doesn't set the rule, why should we set a rule as opposed to proceed on a case-by-case basis?
Well, Judge Rao, I would say that first, with regard to the rule where there's full satisfaction, that was settled. There was no debate in 1865 in the Supreme Court, and that's the exact situation we have here. So I don't think there's a reason to have to create a new common law rule. And regardless, the proportionate share rule wasn't even a known thing until the 1960s. And so that can't possibly be. In terms of going with an equitable case-by-case approach, we were actually surprised to see the government argue for that. I think I know why they are doing that, because they want to be able to choose in every case how much damages they can get. That is a completely unworkable rule, and the authority the government cites for that is CERCLA, where Congress actually did speak, and I think actually proves our case, where Congress wants to allow courts equitable discretion to carve up damages among defendants. It knows how to do that, and it speaks. In this case, where it is silent on it, and I don't want to say they're silent, they just didn't directly address this issue, but they did create exposure for treble damages for joint tortfeasors, and there's a settled body of law, we believe, that answers how you deal with it in that situation, and Congress has never spoken to say that that should not be the rule.
But if there isn't a bunch of cases like this, if this is one off since 1865, let's say, it seems that the position the government's taken is just chasing this case.
It might well be. I mean, that we
what else is at stake? Really, nothing but this case.
Well, I think a question for the government, Your Honor, is why they're taking this equitable case-by-case approach and why they want that to be the rule, which I think I'm not aware of any other area of the law where that's the case, and certainly not where Congress has a statute in place. And yes, I think that they are trying in this case to get more than 3 times their damages.
Let's just play it out for a second. If the government is correct about this and it's going to be case by case, then what does that do in terms of the effect on settlement?
if the government is correct,
Yeah.
I think it will make for a very chaotic False Claims Act situation because, for instance, if everyone knew that the government's new proposed rule was the rule 13 years ago when this case was brought, I suspect we would have had a lot different litigation. The parties probably would have sought to have their cases consolidated so that proportionate and comparative fault could have been determined in one case. But that's not what happened. And so these cases proceeded on separate tracks. There was no cross-discovery between the Toyobo case and the Honeywell
Right,
case.
but looking to the future, when
Yes.
new cases come along and that's the government's going to, pardon me, the court's going to decide which rule is to be applied, how does that affect stuff?
If the court adopts Honeywell's proposed rule, I don't think it will change things at all because parties,
If it adopts the
defendants,
government's.
if we adopt the government's rule, there will be intense cross-litigation among co-defendants trying to blame one another for the same fault, and it will create many trials within trials, and we will have the situation that we would have in this case on remand, where the whole trial will now become Honeywell versus Toyobo versus Armor Holdings, rather than the question presented, which is whether Honeywell submitted a false claim, which incidentally, I'll just say Honeywell did not, but that I understand that's not at issue here. But that is exactly what will happen, and this case would have been discovered and litigated very differently if we had known this was going to be done.
Mr. Primus, what, if we're deciding between the pro tanto and the proportionate share approach, how much weight should we put on the purpose of the False Claims Act? So the government argues that it's in part punitive, and you argue that one of its main purposes is compensatory. I mean, how do we think about that in terms of picking between the rules?
Your Honor, I think this court said in Semino and has recognized elsewhere, as has the Supreme Court in recent statutory construction cases, that trying to define the purpose of a statute is very dangerous business. And as Judge Katz has said in the Allen case, it opens the door to, and as this court said in Semino, it opens the door to judicial policymaking. And so we don't resort to the common law at the time the statute was passed just because the Supreme Court said to do that. There's a serious separation of powers reason for that, which is to guide judicial decision-making and interpretation of statutes. And so we would submit that the purpose case law on the False Claims Act is less than clear. The Supreme Court has said both that it is punitive and that's compensatory. In the antitrust cases, which also have treble damages, the same thing occurs. And there's no judicial line between where it becomes compensatory and punitive in any given case. So we think it's very dangerous, and we think the common law answers this question.
So I have just a question about the record. Do I understand the government, I think I saw this in a district court decision, the government is seeking, $17 million from Honeywell?
The government is seeking $11.5 million on the False Claims Act count, and then it's trebled to about $34.5 million.
Well, what about from Honeywell specifically?
That is the amount. Oh, just to be clear, the government is seeking 100% of the liability from Honeywell, which means if they prevail.
No, I'm talking about in the district court.
Yes, that's what.
Where did I get the 17 million figure? Isn't that, what did the district court mean by that?
I don't know.
Oh,
There are other counts that might be
I
what you're
see.
talking about. But on the False Claims Act, it's $34.5 million
Okay.
plus penalties.
Okay.
Thank you, Your Honor.
Any other questions? No. Okay, thank you. We'll hear from the, did you have a question?
No, I didn't. Thank you.
We'll hear from the government.
Thank you, Your Honor, and may it please the court. Sean Jander for the United States. I'd like to start, if I can, exactly where the court started this morning, which is with the text of the statute. I think, as Judge Taylor, you suggested, the statute makes any violator liable for 3 times its damages. So the initial, I think, implicit premise of Honeywell's argument that it's entitled to a set-off, it doesn't come from the statute.
Yeah, but what you just said isn't the position the government took in its brief.
So, Your Honor, I think...
You say in your brief the statute doesn't answer this question, which sort of surprised me.
I think the starting point from the statute is that any person is liable for 3 times the damages.
Is what?
Is liable for 3 times the damages. That being said, the government recognizes that there is an equitable principle that entitles joint tortfeasors to set-offs when other joint tortfeasors settle. And the government hasn't contested the application of that equitable principle at a general level is appropriate in this case. But I think the important point here is that Honeywell's argument that it's entitled to a set-off, it isn't a statutory argument. The statute doesn't address that question. it's an argument that itself is grounded in equity. And so I'm not sure how Honeywell can come in and try and sort of start with that equitable premise and then run away from equity when it comes to figuring out, not whether they're entitled to a set-off, but rather whether or how you calculate the set-off that they're
So is it your position that the pro tanto rule can never be used or just can't be used in a case where it results in a person who defrauded the government paying no treble damage?
So, Your Honor, so it's an equitable question. We think the district court.
Wait, why is that equitable? What I just said. Why isn't that statutory?
So, as I said, I think the sort of background equitable principle that's not found in the statute is a principle that.
I thought you just said to me that the problem with Honeywell's position is that it would result in them not paying treble damage.
I think the sort of specific problem with application of the pro tanto rule in this case is an equitable problem, which is that if Honeywell is not paying any statutory damages, that undermines, one, it's inequitable with respect to the other defendants, but two, it undermines the punitive and deterrent purposes of the False Claims Act. And as a matter of equity, I think the district court correctly determined the application of the pro tanto rule in this case does not satisfy the relevant equitable principles.
But what case can you point to that suggests the False Claims Act, these liability questions should be determined on equitable principles as opposed to, say, common law principles or a particular common law rule?
So, I think the whole inquiry is a remedial equitable inquiry. And we cite a number of cases in our brief. So we cite some cases from the False Claims Act context, not to address this particular question, but that gaps fill in other ways in sort of a common law equity focused basis.
Common law and equity are not the same thing, right? I mean, the fact that there's a gap and the gap may have to be filled by a judge-made rule is not the same thing as the inquiry being a case-by-case equitable type of inquiry. And those are distinct concepts.
Yes, sir, that's correct. However, I think when the court is developing a federal common law rule to apply, it's perfectly appropriate for the court in determining what rule is appropriate to fill the gap in any given context to take account of those equitable principles. And to the extent that those equitable principles might be circumstance dependent or might point in different directions in different cases.
Can you point to any case in which there has been a decision a court had to make about setting a liability rule, which it has then proceeded case by case as opposed to picking one rule or another?
So there isn't a ton of case law that specifically
because we couldn't find really, and I don't think any of the cases you cite, I mean, where the court has recognized there's a gap, it always picks a rule.
So historically, that has been correct, Your Honor. I think the one difference is in the CERCLA context where Congress.
But the statute there is distinct.
Right. And most of these cases, right, the statute doesn't address it. Courts have historically picked one rule or the other, but the courts haven't really looked at the question whether they should pick one rule to apply in all cases or whether it would be better to proceed on a
But they
case-by-case
do
basis.
pick a rule, though. That's sort of our practice, is to pick a rule.
That is reflected in the bulk of the case law. That's correct. And I think, as I said, CERCLA is sort of the one place that I know of where Congress has addressed the question. And there, Congress said, at least in certain circumstances, courts should proceed according to the principles of equity.
So I guess I have a question for the government, which is, if we were to pick a rule, which rule should we pick?
We don't think that's the appropriate question.
But assume I
So it
think
will be if
that.
two of you disagree,
Yeah.
two of us
So
disagree with your proposition.
if we think that that's what we need to do in this context, which rule would the government prefer? Because the government sometimes, has argued for the pro tanto approach. So if there's going to be one rule, which rule does the government prefer?
So the government hasn't taken a position on that question, Your Honor. And I think it's sort of helpful to take a step back to try to understand why. And I think in this case, it is a particularly stark example of a context where the pro tanto rule really leads to an inequitable result and doesn't result in furthering the statutory scheme and the purposes of the False Claims Act. But there are other cases where the proportionate share approach in those cases might similarly not further the appropriate purposes of the False Claims Act, might lead to undercompensation. And there are still other cases where maybe both rules sort of further the purposes of the False Claims Act and the statutory scheme similarly, but there are equity reasons or judicial economy reasons that one approach or the other.
It's going to be a complete mess if there's no rule. I mean, how will settling parties have any idea how to proceed in terms of working with the government to settle if they don't know when they settle, whether they'll have to pay a proportionate share or whether their settlement will be final. I mean, how is it going to work when you have so many of these cases where there are many different tortfeasors?
Well, I think as a general rule, settlement is always proceeding in the face of uncertainty, legal uncertainty about what might happen to trial, uncertainty about what a jury might end up doing if the case gets to trial. And I can see that there might be a little bit more uncertainty if the court adopts the government's approach than if the court adopts Honeywell's approach.
A little more uncertainty? You think it'll just be a little bit?
Yeah, Your Honor, I don't think that it's that much more uncertainty. I mean, I think in a lot of cases, to the extent that a settlement generally reflects the proportionate share of a particular settling defendant's liability, then the two approaches sort of come out into a pretty similar result. And of course, I mean, I think Honeywell's approach, one input of that approach is what every other defendant settles for. And so at the outset of the case, each defendant has no idea what other defendants might settle for. And so I'm not sure that adopting that approach really reduces uncertainty on the front end. It might reduce uncertainty once you have a bunch of defendants who have settled and there's one defendant left. But that's a pretty rare circumstance where you have one lone holdout.
What did the Supreme Court do in McDermott? Was that pick your choice, pick your rule as you go?
No, you're right. The Supreme Court in McDermott said that in the admiralty context, the proportionate share rule was appropriate. The court, though, I mean, didn't consider the question whether it should adopt one.
It didn't consider that. It didn't occur to anybody. In fact, I've never heard it suggested. I can't find any suggestion anywhere in the cases or the treatises that there's something other than a rule.
So, as I said, we acknowledge that the cases have generally picked one rule or the other rule, or a third rule, or a fourth rule back in common law days. But that being said, I don't think there's any particular reason that the court should feel compelled to adopt a single rule. And for us, stepping back, the two rules.
I mean, you're just saying the government wants the right to be opportunistic, right? It's not just the government. Well, it's the government in this case, of course, but why would this not spill over into other contexts, torts, and so on?
So I think there's sort of two parts to that question, Your Honor. So taking the second part first, we think that the determination of what the court ought to do should be guided in large part by the statutory scheme and the purposes of the statute. And so I don't think if the court adopts this case-by-case approach that we've been advocating in this context, that would necessarily spill over into other contexts or other statutory schemes. But that being said, I just don't think that it's entirely fair to characterize the government's approach as being the approach that seeks the most money in any given case. And I think, as we said in our briefs, there are also concerns of equity among defendants. There are concerns of judicial economy. Those concerns might be.
How do they? It seems to me they're, even from your account, they are at war here, right? In other words, judicial economy would be set back with the uncertainty, et cetera, and having many trials about proportionality, and whereas on your account, fairness would be advanced.
So I think it very much depends on the particular circumstances of any given case. And so,
well, this case I'm talking about, that's what you're talking about.
So in this particular case, I mean, the district court, I think, considered the judicial economy question and found that in its experience, juries are perfectly capable of making these sorts of determinations. And I think a lot of the evidence that Honeywell points to about what other joint tortfeasors did in this case would likely be admitted anyway to provide context for the dispute, sort of inform the jury about what happened.
How many defendants in this matter?
So in this case, I believe Honeywell is the only defendant.
No, I'm sorry.
But
how many parties against which claims were made?
I'm not sure the exact number, Your Honor.
More than three?
More than three, I would say.
More than five?
Perhaps more than five. Although not all of the defendants are sort of directly linked to Honeywell.
This is not your typical Med-Mal case, right? Two parties, maybe three at the most.
So there are a relatively large number of potentially liable parties in this case, Your Honor, or in this sort of general fraud investigation. That being said, I mean, the district court, I think, looked at this particular question and just determined that given its experience litigating complex trials, this wasn't a particularly difficult problem to solve, and it didn't consider that to be a particularly strong reason to adopt the pro tanto approach in this case. And I think conversely.
Does the government agree that the FCA is a joint and several liability statute?
We have not contested that in this case, Your Honor. My sense of the case law is the same as my friends on the other sides, which is that courts have applied joint and several liability. I'll be honest, I'm not sure if the government has taken an official position on that question. I wouldn't want to take one without being authorized to do so, but that has been the rule that courts have applied.
The FCA nowhere requires the determination of proportionate fault, does it?
Not as part of the statutory scheme, or sort of in general. No.
Right. So if we were to choose a rule, I mean, doesn't the pro tanto approach seem more consistent with the FCA than the proportionate share?
I don't think so, Your Honor. I mean,
or do you think one of these approaches is more consistent with the statute? When you started, you said we should be focused on the statute. So does the statute suggest one approach is preferable or more consistent with one approach or another?
But either approach may be more consistent with the statute in a particular case. And I think that just underscores why picking one approach to apply in all cases, it isn't the appropriate way to go about it. And in this case, the proportionate share approach is more consistent with the statute. It furthers the statutory goals of deterrence and punishing.
So is that just the purpose of the statute that you're referring to, or is it some particular provision of the statute?
I think it's the statutory scheme, and in particular, the damages provision, which, of course, aware is a treble damages provision. The Supreme Court has characterized that as reflecting Congress's understanding that part of the statute's purpose is to deter fraud against the government, to punish past fraud against the government. And those just are goals of the statute that would not be advanced. I think it would be utterly undermined in a world where Honeywell is allowed to escape with no statutory damages whatsoever, simply because.
Under your no rule, I suppose a district judge could look at the, let's say, plethora of parties against whom a claim is made and say, this is just too inefficient. We're not going to go through determining proportionality for 13 different companies. So we're going to use the pro tanto. And another district judge could look at that and say, you know, I don't see a problem with that. I've got cases with 13 claimants, claimees, I guess. So I'll use the other one.
So I think it's correct, Your Honor, sort of as an initial matter, that sort of question to consider is one that we think is perfectly appropriate for district courts to consider in determining which rule to apply in any case. And it may be the case that different district judges or different district courts would balance the relevant considerations in different ways. But I think that's just a common feature of sort of equitable discretionary inquiries. I don't think there's anything specific about this inquiry that is particularly problematic in that respect.
How much is the government seeking from Honeywell?
So the underlying damages from Honeywell would be somewhere in the neighborhood of $34 million.
Of how many?
The government would.
How many? I'm sorry. 34, you said?
That's correct, Your Honor.
Is that trebled or?
Trebled.
That's trebled. Okay.
And then the government concedes that Honeywell is entitled to a credit for the proportionate share of other defendants' liability, which would reduce that $34 million by some amount. I don't know what the jury would say that the proportionate share is.
Wait. So the government agrees that the 34 million can be reduced.
Correct, Your Honor.
And is that the amount of the reduction to be determined by the jury?
Yes, sir. So under the proportionate share.
Didn't the district court mention a credit of 18 million or something?
So I think the portion of the district court opinion that you're referring to, Your Honor, is where the district court sort of said, if I were to adopt the pro tanto approach, here are sort of, the government had an expert that said, this is how you would apply the pro tanto approach. Honeywell had an expert that said, this is how you would apply the pro tanto approach. And that was the government's expert applying the pro tanto approach.
All right, so if we agree with you, then we say, I'm not sure what the rationale would be yet, but we say the pro tanto approach is not appropriate in this case, correct? And then we send it back to the district court.
Correct.
We say nothing else.
Right. I think all you would need to say is the district court did not abuse its discretion in determining that the appropriate approach in this case is the proportionate share approach.
I see. And what's your response to Mr. Primus's argument that under the government's theory, it's going to receive more than treble damages of its loss, treble its loss?
So I think that argument, Your Honor, was squarely rejected as particularly persuasive by the Supreme Court in McDermott.
Well, McDermott wasn't a False Claims Act case.
That's correct, but I think it's actually more persuasive, or I guess that argument is less persuasive in this context. I mean, McDermott was not a treble damages case, so the punitive and deterrent rationales of the statute or of the regime were even, I think, less evident. And there, the Supreme Court said there's no rigid rule against overcompensation, and sometimes it's more important to make a tortfeasor pay for the harm the tortfeasor has caused than to prevent over-recovery. I think that's even more true in this context where we're talking about a fraud on the government, on taxpayers.
Well, what do you do with the fact that the statute says treble damages of its losses, treble its losses?
So the statute says, Your Honor, that each violator is liable for those treble damages. It doesn't say, I mean, number one, it doesn't say the government should not be permitted to recover more than treble damages in circumstances like
Doesn't
this.
doesn't it say, it says any person who defrauds the government is liable to 3 times the damages caused by the, quote, act of that person. Act of that person, not all the government's losses, just that person's loss.
Correct, Your Honor. So the 34 million, the treble 34 million, which is kind of the bottom line or top line number, it is only connected to the false claims that relate to Honeywell's alleged misrepresentations. So that's how we sort of focus in on Honeywell's misconduct in this case, and that sort of provides a starting point for any application of either.
Anything else? Okay, thank you.
Thank you.
Mr. Primus, you are out of time, excuse me, but you can take 2 minutes. Yeah.
The position the government is taking here is really extraordinary, and they haven't taken a position. Quote, I haven't taken a position on which rules should apply. The government concedes pro tanto does apply, and I suspect in most cases that's the rule they would want to apply. And so they're asking this court to really upset and create a lot of chaos in False Claims Act law to obtain a judgment against one party. And it will cause, it is not consistent with the statute and will cause great havoc. I also just want to be clear in response to Judge Ginsburg, the government is seeking 100% liability from Honeywell. So they've already recovered full amounts for the vests at issue, and they're going for 100%. A jury may or may not.
What are the dollar amounts?
Excuse me?
What are the dollar amounts? What have they recovered?
They've recovered, for purposes of vests that contain Honeywell's product, $35 million or $36 million, and they hold us, or they say we're liable for 34 and a half. So at the end, they'll have 70 million if they're successful at trial.
So
And the
you
statute
think
certainly doesn't support
we
that.
should then ignore the statutory requirement that any person who defrauds the government is liable to 3 times its damage. We're going to ignore that. In this
Your Honor,
case, right?
I do want to address the textual argument too. The statute says, and I think Your Honor skipped the part about civil penalties. And
No,
it
I
says-
didn't. I didn't. I know it says civil penalties, but so far the government isn't seeking civil penalties, as far as I know. Maybe
it
it
is.
will, but it says civil penalties plus, right?
Correct.
Okay.
So what I wanted to respond,
Yeah.
Your Honor, was that under the plain language of this statute, Honeywell can be liable if it is found to have committed this false claim, liable to the United States government for a civil penalty of not less than $5,000 and not more than $10,000. And we have not disputed that. So that part of the statute can certainly still be enforced as written.
But suppose the
With regard to
damages,
three
just
times.
suppose the damages, instead of being $34 million, are, say we had the exact same case, except the damages were $100 million government was seeking. Certainly a fine of $5,000 to $10,000 isn't going to compensate the government.
It depends on the number of claims.
Wait a minute,
in a
okay,
particular case.
let's say there's just one, or two parties, that's all. $100 million, and
Well, if-
it says plus. What do you do about the word plus?
Well, that's textually, you have the liability for the civil penalties, which still exists. And then for the 3 times the amount of damages portion, we say that that can be interpreted as written, subject to the offsets that both parties agree exist in this case.
I was just responding to I understand that's your argument. You seem to be suggesting that maybe the $5,000 to $10,000 civil penalty is somehow compensatory to the government.
No, the point there is just textually, the statute still has financial exposure for a defendant who is liable, even with the offset approach to the 3 times damages.
Okay.
And in addition, that is the penalty. It's a civil penalty. That is the punitive portion.
Mr. Chris, isn't the question, what does it mean to be liable? I mean, the statute doesn't say that a person will pay 3 times treble damages. They're liable for treble damages. And being liable doesn't always mean that.
Your Honor, that was the point I was trying to make, which is that Honeywell, under the reading that we're proposing, can still be held liable for a false claim, still be subject to the civil penalties, still potentially be subject to the 3 times the damages, unless they're offset by other people who have already paid. That is our textual.
Is there a collateral consequence to being held liable under the False Claims Act? Are you forbidden from bidding for a while or things like that?
Yes, Your Honor, that's, if we're talking in the world of purpose, again, which we don't advocate, but certainly there are other consequences to Honeywell if it is found liable. There's the penalty provision. There are reporting obligations in federal government contracting. There are discretionary determinations that can be made by government agencies with a party that's found liable for a false claim. So it's a serious business,
It could be
even
debarred.
with the offset. There is potential debarment, although I want to say for the record that I don't believe that would be appropriate in this case. But yes, those are all serious risks that any False Claims Act defendant faces, regardless of whether they pay 3 times damages or not.
All right. Anything else? Okay, thank you. The case is submitted. Morning.
Case number 20-1256 et al. United Power Inc. petitioner versus Federal Energy Regulatory Commission. Mr. Patrizio for the petitioner, Mr. Glover for the respondent, Mr. Steele for the interveners.
Good morning, Your Honor.
Good morning.
I'm Charles Patrizio, Paul Hastings Law Firm. The issues before the court, whether the Federal Energy Regulatory Commission erred in asserting jurisdiction, FERC failed, indeed determined would not make necessary material factual issues necessary to make its jurisdiction. And then second, FERC erred in asserting exclusive jurisdiction over all issues related to the determination of exit paid by in order to terminate membership. Our argument is FERC.
Can I ask you to step back and first address the commission's argument that none of your 3 major arguments were preserved? Let's just go through each one of them.
There's 2 answers. Please. The first is the issues were preserved. The hearing cited in the brief are references in the Joint Appendix at 576 specifically identified the issue of whether or not state law complied with.
Well, the FERC's position is that none of those points, none of the language you point to in your petitions before FERC are specific enough under this court's very strict rules about preserving arguments in the FERC context. We've said this is, quote, an unusually strict requirement that will not be ignored by the courts. And FERC's position is that none of the things you point to in all 3 arguments was sufficiently specific to put FERC on notice.
There's 2 answers again to the The first is that although the court correctly says that the rule is strict, that the issues must be raised, the court has also made it clear that all that is required is to put the commission on notice of the issue. Fairly clear it has an issue to decide. Here, the commission is clearly, because the commission itself said, both in the March order and in August, that it was aware of those issues and it was specifically not determining those issues.
Can you
You're referring
distinguish?
to the contract issues? Or is it, pardon, you're referring to which issues now?
We're referring to the state law issues.
Okay, all right.
Specifically,
Okay, that's what I
whether or
thought.
not
Right.
the ACO was properly.
Can you, the commission cites our decision in Indiana Utility Regulatory Commission. Are you familiar with that case?
Yes, sir.
Okay. It seems to me to be right in point. The argument there, the argument there before the court was that the commission should have considered state law before it issued its order. And in its petition to the commission, the utility said, having the retail utility bear a certification requirement is an impingement on Indiana's jurisdictional authority. And we said that wasn't enough. We said that was too general.
Yes, sir.
It looks just like this case.
Well, I think the other point here to make is that United Power specifically lodged with the commission testimony in the underlying C proceeding, which specifically.
No, you have to raise it in your petition. It has to be raised under the statute. The argument has to be raised in the petition to the commission.
It has to be raised before the commission in the objections and in the notice. That logic was specifically done to the commission to identify the state law issues that were of concern and were not being addressed. And the commission then said, to the extent United Power is raising state issues, we're simply not going to determine them. Rather than the commission saying, oh, gee, we're confused about what state law issues there are, the commission said, we're not going to determine any of them.
But then in your application for rehearing, you argued that FERC should wait for the state court proceedings to conclude. You didn't argue that FERC should decide the state law issues itself.
FERC had told us that it did not want to decide those issues and it wanted to defer to the state. Therefore, if FERC continued in that view and did not want to decide those issues, it should wait for the state law determination.
Right, but now before this court, you're arguing that FERC should have decided the state court. If it wasn't going to wait for the state court proceedings, it should have decided the state law issues.
Exactly, Your Honor.
But you did not raise that argument before FERC.
FERC having said to us that it was not going to determine those issues and it would defer to the courts, we took FERC at its word. But that means that FERC under Michigan v. EPA cannot assert jurisdiction. If FERC wanted to assert jurisdiction, it would have to have those state law issues decided. FERC wants to defer it.
That may well be true, but I don't believe you raised that argument before FERC.
Said it was premature for FERC to take jurisdiction without those issues being decided. We noted that if FERC wanted to defer to the states, it had that ability to do that. FERC does that routinely in state law issues.
Even if you're right that that particular issue was preserved, that is that FERC had to wait for the state commission to act as opposed to FERC deciding it itself. What's the possible? FERC says, look, we had a rate filing before us. We had to decide that. And we have lots of cases that say we don't intrude in FERC's allocation of priority in the way it decides cases.
Exactly, Your Honor.
So how could we possibly second guess that? I mean, FERC made this decision. It has an enormous amount of discretion to decide how it will act. It says it had a rate filing that it had to decide.
There are two issues buried in that, Your Honor. I want to parse them separately.
Okay.
The first is that FERC has no duty to decide a rate case if it doesn't have jurisdiction over.
No. I'm not asking you about that question. I'm asking you about the other question. You have two arguments. One is, as I understand it, you have a jurisdictional argument, right?
Yes, sir.
That FERC couldn't act without resolving the state issue. And then isn't your second argument that even if it's not jurisdictional, FERC should have just waited for the state to act?
No.
That's not what you're arguing?
That's not what I'm
Oh, I misunderstood
To
your
the
brief.
degree
Okay.
FERC asserts it has jurisdiction, has to make a finding, necessary factual predicate and legal predicate.
Mhm.
It has no duty to decide a rate case. It has no duty even to accept unless it has jurisdiction. The issue of whether it has jurisdiction is preparatory predicate for the determination of jurisdiction. If it has no jurisdiction, determining the rate would be nunc sufficio. It has no jurisdiction to hold them.
Have you said anything yet about preservation of the argument challenging jurisdiction, the Commission's jurisdiction? And not the conditional jurisdiction with the state issues, but rather the jurisdiction that you, as I understand it, point to, for which you point to page 541, note 6. Said anything further about that?
FERC only has jurisdiction over Tri-State if Tri-State is not owned exclusively by member Columbia. To the degree that Vieco's admission is the predicate for the determination Tri-State is not fully owned by cooperative utilities, then that issue was preserved. Indeed, we spent a lot of time in our materials before FERC on the issue of whether Vieco was properly.
Well, maybe I'm mistaken. I thought your threshold issue was, as you just said a moment ago, the secondary, which was even if they had jurisdiction, they should have waited, right?
No, Your Honor.
Okay,
even
sorry.
if they have jurisdiction,
Yeah.
then they did not properly determine the issues related to first of all.
Okay, all right, good enough, good enough. I want to go back to the beginning as to whether they have jurisdiction, okay, to begin with. And as I understand it, you say you preserve that issue by mentioning it at 540 in the rehearing. Right?
541 and 547.
Okay, well, I'm looking at 541. Maybe 547 is more illuminating. In 541, it's a footnote 6, which
Yes, sir.
it doesn't degrade it. There's no mention of the word jurisdiction. There's no argument made. There is what appears to be more an address to the Commission's discretionary decisions. Or here's how it reads. United Power notes the Commission recognized there are significant state law issues, blah, 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 and that those issues are before the Colorado PUC, which is better suited to determine the state law issues. Commission's determination of Tri-State's jurisdictional status while the state law issues remain to be fully determined by a better qualified state utility commission is premature as well as inefficient. Now, premature and inefficient are not jurisdictional criteria, right?
Well, I would
And there's
say
no
to the-
suggestion that you're talking about lawful jurisdiction.
I would say to Your Honor, the statement that it is premature for FERC to take jurisdiction while there are state law issues pending is exactly a question of FERC's jurisdiction.
Well, you might have said so then and called their attention to that and let them respond to it.
But FERC acknowledged that we had called their attention to it by saying in both the March and August order that it was not going to determine the state law issues, and it recognized that those issues would have impact on FERC's jurisdiction.
What is it at 547 I should look at?
Yes, sir. In the beginning of the second page, talking about whether the commission's analysis of this government begins and ends with, and citing only the membership. Charter and principle. Declaratory summary concludes the Tri-State critical.
Any mention of jurisdiction?
Then the issue of jurisdiction. Requires is unless exclusive. The issue is whether is
Go ahead. Did you have a question?
I mean, that may well be true as a merits matter, but it doesn't seem fairly raised by the arguments that you made before FERC. I mean, if FERC was to decide the state law issues, there's no briefing at all to FERC about how those state law issues should be decided or how they should think about those state law issues. I mean, it's hard to.
No briefing on the issue. FERC said, we're not going to decide the issue. FERC said to us,
well, they said that in their initial order, and then you made an application for rehearing and did not say they must decide the state law issues because that's a predicate of their jurisdiction. Instead, you raised all of these arguments about the bylaws and articles.
AECO's membership is the predicate for the issue. If the AECO's membership FERC has, FERC said, we're not going to decide those issues. No. The decision on those issues. FERC recognized that this isn't some obscure issue that FERC was not aware of. AECO membership was.
You also argue that FERC's interpretation of cooperative ownership runs afoul of the Federal Power Act, right?
Yes, sir.
But maybe you could show me in the petition before FERC where you made that argument. I see where you made an argument that it violates tri-state's bylaws. But I didn't see where you made an argument that it violated the Federal Power Act. Could you show us that?
Well, for example, in turning to 7 appendix, note that the Commission no analysis tri-state's own term, long-standing principles of cooperative arrangement, and undertook otherwise noting in a couple of pages that membership issue was putatively required.
Okay.
This court held earlier, called River King, that a cooperative is an entity which is owned by its.
Yeah, that's the merits. I was asking where you raised the argument. Do you have anything else?
I did have one question about if you were to receive a favorable ruling in the Colorado state courts, do you think FERC would be required to revisit its jurisdictional holding? What would be the path forward if you were to prevail in Colorado state court at this point?
Yes, FERC would determine any basis under 201 F. Exclusive. Remember, holding state court, AECO was member, there would be no basis for jurisdiction. Congress, tri-state's interest in being.
Okay. Anything else?
No.
Okay, thank you.
Thank you.
We'll hear from FERC.
May it please the court, I'm Matthew Glover, and I represent the Respondent, Federal Energy Regulatory Commission. It's great to be back in the courtroom, and I really want to thank the court staff and Cliff Sislak and Ann for everything they've done. And I think I'll start with the jurisdiction questions that we've been discussing with my friend. Judge Tatel, we think you're absolutely right that Indiana regulatory is on point. And I would actually note something that the court said in Indiana regulatory, which was it matters not whether FERC is aware of the issue. And there, the context was someone else had raised the issue in their rehearing petition. So it matters not whether FERC is factually aware of the issue. It matters whether this specific party has raised the issue, and it distinguished the sort of strictness of this jurisdictional provision which the court said many times, with a traditional exhaustion provision that could be waived. I'd like to respond to the argument regarding the footnote. It's footnote 6 at JA 541. In their reply brief at page 21 at the top, they say this court has previously found jurisdiction where an issue was only raised in a footnote. And they cite one case called Columbia Gas. And that's just not true of Columbia Gas. And I'm aware of no case where the court has said you've sufficiently raised something. But in Columbia Gas, the court quoted the rehearing petition. It had a quote of a sentence from page 12. And then it followed up with a sentence describing that.
Wait, are you saying that you can't raise an argument in a footnote? I mean,
I'm aware
if I were making the rule, I would agree with you. But is there any way the DC Circuit has said that?
So the DC Circuit has said that about identical language in the SEC's jurisdictional provision, the SEC jurisdictional provision 15 USC 78Y subsection C1 has the same language. No.
Yeah, and we've said in that context that you can't raise an
I
argument
believe
in a
the
footnote.
case it was last year, a case called Abbott. I'm embarrassed. I don't know off the top of my head. It was argued December 1st, the same day as two cases I had argued. But the court there criticized a party for citing stuff in the background of their brief, and it cited some of the.
Okay, the background of the brief, I've got you.
Yeah,
They can't do that. But where's the footnote rule?
And it cited there, I believe, some other cases related to where this court has said in its own case law, you can't raise something in a footnote. You're opening.
Is that really what you want to rely on, Mr. Glover, that it was in a footnote as opposed to the substance of the footnote doesn't preserve the issue?
So I think I have all of those arguments. Let me back up and say, first of all, we think it's in a footnote to the introduction section, and so that wouldn't do it. We also think that it substantively did not say you must decide the Colorado state law issues or you don't have jurisdiction.
Well, that's at least relevant. Now, I mean, look, we have innumerable cases in which a party wants to preserve an issue by which the panel is bound. It's preserving it for en banc or for Supreme Court review. And it puts it in a footnote. We don't say you've waived it. It preserved it.
Yeah, but I think this is a stricter standard because it's about raising it to the commission so that the commission can decide something. And again, I'm not aware of a case where you've said you can put it in the background of your brief or you can put it in a footnote. But substantively, we don't think that footnote actually raises the timing jurisdictional challenge they're asserting.
Well, now you're onto it. So, right, that's my question. Go ahead.
No, I think you were asking my friend on the other side about JA 541 note 6, and we don't think 541 note 6 says the argument they're presenting today. It says note that we note the commission has recognized there's significant state law issues, and this is premature as well as inefficient. Sounds like the commission's discretion, like you were discussing. And I think this contrasts significantly with one of the cases they cited in a bullet point, I believe at page 22 of their brief. It's the Louisiana case. That had to do with a pipeline segment, and there the petitioner had raised in rehearing, if you decide that this segment of the pipeline is a unique segment, then you need to decide two additional issues. And first, in the court's opinion saying there was enough to have raised it in the rehearing petition, it noted that the issue they were now pressing before this court was identical to that statement. If you decide this, you need to decide two more things first. That first issue that they stated there. This footnote doesn't even do that and say, if you reject our arguments about the articles of incorporation and the bylaws and the sham transaction, you must then decide whether or not NIECO is its bylaws or its purchase agreement complies with state law. It doesn't even do that.
But what about your colleague's argument that FERC had already indicated quite clearly that it would not address the state law issues? And so in the context of FERC saying, we will not address the state law issues, they didn't then make further arguments about state law in their application for rehearing.
Your Honor, the commission stated what it had held and what it was not deciding, but they didn't make the argument that you have violated your jurisdiction and you must decide these issues. Again, they didn't make that argument in that footnote. And again, when the commission stated what it stated in the first and the second rehearing order was just recapitulating basically, here's what we've decided, here's what we haven't decided. It wasn't responding to some argument that you need to decide this. The commission.
So what is FERC's obligation, though, to properly determine that it has jurisdiction? So, under Michigan v. EPA, it seems that you had to have made some determination of state law before asserting jurisdiction, or at least arguably that was a requirement that the commission had to meet. So if the commission fails to make a proper jurisdictional finding, and then a party fails to exhaust that argument, now FERC is allowed to assert jurisdiction over an area without proper reasoning. I mean, is that where we are?
So I'm going to take a quick break. Sorry, it's been a while since I did this first.
Same for us.
I would make a couple of points. Again, the 313B or 16 USC 825LB is jurisdictional as to this court's jurisdiction to raise that argument. So
No, I understand, but I'm just saying like that. Yeah.
But if I can take your hypothetical a step forward and say, like, let's say FERC did what the EPA did and actually said, we're not deciding whether or not Mieko is a member, because the EPA and Matt said we have authority to decide what's Indian country. We're just saying this is in question so much. FERC had said there's a question about whether or not you're a jurisdictional entity, and so we're going to pretend you're one and exert jurisdiction. And they didn't raise that on rehearing. In this case, you would still have to reject it because they didn't raise it on rehearing. But they could come back with a declaratory petition to FERC tomorrow, or maybe after seeing the red brief, and say, gee, you are exceeding your authority every time you assert jurisdiction by not deciding whether or not there's jurisdiction. But the commission was clear here that it did decide for purposes of section 201F, 16 USC 824, subsection 10. Mieko was a member. It went through the bylaws, it went through that, and it went through its analysis pointing to Enron, K.N. Wattenberg.
I mean, the commission looked at the underlying documents, the corporate documents, and it put aside state law. So it wasn't actually making a full jurisdictional finding. I mean, because FERC acknowledges that the state law issues were relevant, but then did not consider those state law issues.
Yeah, absolutely. I think it's paragraph 76 of the declaratory order. FERC acknowledges that it's not deciding those state law issues.
But that they're relevant and that they are not being decided.
That they could have an impact. The commission was saying, this is a declaratory order proceeding. You've given us this record. On this record, we've made a determination on the federal law question of whether tri-state is jurisdictional under 201F. We're determining that you are jurisdictional because we think you are no longer wholly owned. We were interpreting that part of 201F as what's wholly owned by non-jurisdictional entities. We're not addressing state law issues. And again, we were saying if something changes on state law, if something changes on the facts, if Mieko tomorrow, or Marubeni owns Mieko, if tomorrow or yesterday, Marubeni had sold Mieko to the Department of Energy, you'd come forward and say, whether Mieko is an owner or not doesn't matter. The Department of Energy is an entity of the United States. We would be exempt under 201F. Right? The commission was ruling on the record before it deciding the federal law issues.
So would the commission be required to revisit its jurisdictional holding if United Power prevailed in Colorado State Court?
Certainly United Power could in the ongoing proceedings or could initiate its own declaratory order proceeding saying, we have the state court ruling. We think that nullifies Mieko's membership. We think it nullifies it going forward or going backwards. That would depend on sort of what's going on there. And the commission would, have the opportunity to say, does that change our decision? We made a decision under 201F, and on a different record, we might make a different decision. It's similar to sort of the distinction between the Delta Montrose case. The commission decided on the record there that under 201F, Tri-State was exempt because it was owned solely by public utility members. Here, it decided on the record here. Factually, Your Honor, there is some notes, and I know the 28J opinion noted this. Tri-State now has 2 additional non-utility members. So a ruling on Mieko's membership, I think you would still need to address whether those other non-utility members are exempt entities, et cetera. I'd like to just quickly pivot to respond to one other point in the reply brief. In the reply brief at page 27, they described it as an alternative argument not made in the first rehearing order that the commission treated the exit charge as a charge or fee for or in connection with provision of jurisdictional services. That's quite clear in the second rehearing order at JA 94, paragraph 5. The commission quotes section 205A, which is 824DA, and italicizes that language for or in connection with. So I don't think you can argue that the commission didn't make a determination as to that.
Well, I mean, it's an assertion. There's no argument for it. I think it says, or at least in connection with, right? Directly affects, or at least is in connection. Correct?
It's
Paragraph 5. What's the page on that, Mr. Glover?
I believe it's JA90.
Yes.
Yeah, section 205A refers to all rates, charges made, demanded, received by any public utility. I know I'm in the red light.
Or in connection with.
Or in connection with, in italics, the transmission or sale of electric energy subject to the jurisdiction of the commission, end quote. That's quoting the statute. Tri-State's exit charge falls within this.
It's in connection with, right?
Yeah, with the provision including the or in connection with, or in connection with.
No, but is it for or is it in connection with?
The commission is saying that it falls into that provision that includes. You know, I think
But it's got an or.
Sorry?
It's got an or. It says for or in connection with.
Yes, and it's saying that.
So is it, which one is it?
The commission didn't say whether it's for or in connection with. It said it fit within that provision
I see.
that covers the
Well,
jurisdiction.
what do you think?
I think that it's at least for or in connection. It's at least in connection. Well, let me say, Your Honor.
I don't blame you. You can't go beyond what your client has said. That's fair. Okay.
And I just sort of to give you the lawyer's view on the law, I think it's fair to say that for is more direct than in connection with.
Yeah, no
So
question
in
about it.
connection with being broader, it's at least in connection.
Okay, fine. That's great. Okay.
I know I'm over time if the court has no other questions.
I don't have any. Do you have any? No. Okay. We'll hear from the intervener then.
Thank you.
Thank you.
Please the court. Simon Steele on behalf of interveners, respondents. Just to be clear, that is on behalf of Tri-State, party interest, 2 Tri-State members, Northwest.
Mr. Steele, it's very difficult to hear you. Could you raise the, I think the whole podium comes up. Oh, okay.
There's a button there.
Is that any better?
Yes.
Yeah.
Okay. Apologize. Okay, so on behalf of the interveners, respondents, we agree with everything that FERC has said, brief said, as you're aware. So I'd just like to make a couple of points and then answer your questions about that. If I can just go in reverse order first and just address the preemption issue. The commission obviously decided this was a rate charge for or in connection with service, as you just discussed. However, sections 205 and 206 of the FEA make no distinction between rates and charges and classifications, practices, and regulation affecting rates and charges. If we have a practice or a regulation or a rule or contract affecting charges, we must file charges, must determine just and reasonable, just as it must determine charges. As such, while we agree with properly exit charges here, properly charges, we submit it doesn't matter. United essentially concedes, pages 46 to 48, its initial brief, that exit charges in this case, at least classifications, Tri-State charges in its west, and exit charges regularly something that the Commission addresses within its jurisdiction. United, therefore, ends up intending that there is trichotomy. There's 3 types of things. Yeah. Wholesale charges, exclusive jurisdiction, retail generation matters, state exclusive jurisdiction, and then there's this weird category of things directly affecting charges and rates, which supposedly current jurisdiction. They cite no precedent supporting that. There are tons of Supreme Court precedents cited saying nature of the scheme is it's exclusive, it's a dichotomy, it's either one or
sometimes very fine. It's either a state isn't concurrent jurisdiction. And in their 2020, it's called hell classifications, practices, regulations, just briefly, if I may pivot to the jurisdictional issues and bypassing the waiver issues we discussed. As Judge Rao pointed out, if the issue is preserved, it's preserved footnote 6 on page 5. That footnote does not say FERC should decide itself. It says the state agency should decide. Indeed, specific, it says this is a decision should have waited OPA to make. Later in 2020, as we cite page 12, footnote 12, OPA answered the question. Its answer was that was not our decision to make. We received to decide.
Any questions?
No, thanks.
Okay, thank you. I think you're out of time. And council was out of time, right? Yeah, okay. Mr. Progizio, you can take 2 minutes.
Very briefly. Hearing said that as such, Vieco is not a member. I state fully exempt. Also, the declaratory order of analysis is that the commission has overstepped taking Vieco's reported ownership. Secondly, language is for contract or the sale of the Supreme Court. Honestly, is not in connection.
Well, what is your view of the intervener's argument about the fact that even if it's not a rate, it's directly affecting a rate?
The Supreme Court has said not enough for it to affect must be targeted in order to feel certainly a first aid agent can have conflict. That would be conflict. FERC didn't argue. It argued field. Here, the Supreme Court must be targeted.
Thank you. Case is submitted.